This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. I'm going to go over this person and what in the world she is doing with a bottle of Bud Light with what looks like tissues stuffed into it. Do we know anything about stuffing tissues into a bottle of Bud Light? Would it happen to have anything to do with this man? No, not at all. Not at all, right? Well, I'll let the government tell the story. So this is a U.S. attorney's complaint against Collinford Mattis and Arouge Rahman. And for comparison purposes here, Collinford is on the left and Arouge is on the right. So Collinford Mattis on the left and Arouge Rahman on the right. On or about May 30th, 2020, within the Eastern District of New York's jurisdiction, the defendants, Collinford Mattis and Arouge Rahman, did knowingly, intentionally, and maliciously damage and attempt to damage and destroy, by means of fire and one or more explosives, a vehicle and other real property used in interstate and foreign commerce, and in an activity affecting interstate and foreign commerce, to wit, a New York City Police Department vehicle in Brooklyn, New York. On or about May 30th, 2020, approximately 12:57 a.m., an individual later identified as the defendant, Arouge Rahman, exited a tan minivan and approached a New York City Police Department vehicle parked in the vicinity of the NYPD's 88th precinct, located in Fort Greene, Brooklyn. So we're somewhere here, Fort Greene, 84th precinct. 88th precinct over here. So here's where we are. The 88th precinct looks like this, about a block and a half, down here on DeKalb Avenue. Video surveillance from the NYPD's 88th precinct captured the events. After the defendant, Rahman, approached the NYPD vehicle, she lit and threw an incendiary device comprised of a bottle containing an incendiary chemical, sometimes referred to as a Molotov cocktail device, into the NYPD vehicle through a previously broken window. Keep that fact in your brain. Previously broken window, which set fire to the console of the NYPD vehicle. The defendant, Rahman, then returned to the tan minivan, which fled the scene. Law enforcement observed the defendant, Rahman, throw the Molotov cocktail into the NYPD vehicle and followed the tan minivan during its attempt to flee. Shortly thereafter, an NYPD patrol vehicle stopped the tan minivan, later identified as a tan 2015 Chrysler Town & Country minivan with New York license plates, in the vicinity of 200 Willoughby Avenue. NYPD officers thereafter placed the driver, defendant Collinford Mattis, and the passenger, defendant Rahman, under arrest. During the arrest, officers observed, in plain view, several precursor items to build a Molotov cocktail, including a lighter, a bottle filled with toilet paper, and a liquid suspected to be gasoline in the vicinity of the passenger seat, and a gasoline tank in the rear of the vehicle. And that's the complaint. Okay. So great. So they were arrested, they were thrown in jail, and then there was a bail hearing held, and the government wanted no bail. Zero bail, as in not they don't have to pay bail and they get out, but rather they don't have to pay bail and they stay in. So let's see what the government asked for here. This is a little bit longer, but it contains pictures and we're going to skip through it. So this is a similar thing. They say that during the demonstrations protesting the death of George Floyd, certain individuals and groups of individuals unlawfully obstructed the flow of vehicle traffic and refused commands, and officers had to leave vehicles on the streets and return to the sidewalks. Some individuals vandalized vehicles and businesses with graffiti, and by smashing the vehicle's windows with heavy objects. Some individuals targeted the NYPD, vandalizing vehicles that had responded and attempting to gain access to NYPD station houses, etc. In the early hours then, we come upon the 88th precinct in Fort Greene, Brooklyn, on the early hours of May 30th, 2020. Upon identifying the NYPD vehicle, Rahman exited from the passenger side door of the minivan, lit and threw the Molotov cocktail. It set fire to the console of the vehicle. They returned to the minivan and fled the scene. It was captured on surveillance cameras. Shortly thereafter, they stopped and placed Mattis and Rahman under arrest, and they found the Bud Light beer bottle filled with toilet paper and gasoline. When they were initially taken into custody, prosecution commenced 1-count complaint. Then a witness came forward and provided authorities with a picture of Rahman and Mattis in the tan minivan earlier holding the Molotov cocktail. Witness stated in sum and substance that Rahman attempted to distribute Molotov cocktails to the witness and others so that others could likewise use the incendiary devices to further more destruction and violence. So this is apparently a rather good picture that someone got of them. And there she is holding the Molotov cocktail. And here are their arrest photographs dressed in the same outfits they were wearing that night. Do I dare detect a hint of a smirk on her face? I don't know. Could just be awkward photograph. It's a pretty awkward time, getting your photograph taken like that. So here's what the government has to say. Under the Bail Reform Act, federal courts are empowered to order defendants' detention no bail, detention pending trial upon determination that the defendant is either a danger to the community or a flight risk. So in this case, they're going to argue that they are a danger to the community. A finding of dangerousness must be supported by clear and convincing evidence. The Bail Reform Act lists the following factors to be considered: the nature and circumstances of the offense, the weight of the evidence, the history and character of the defendant, the nature and seriousness of the danger to any person in the community. For certain offenses, including this is very important, listen up. For certain offenses, including the offenses charged in this complaint, the law presumes there is no set of conditions that will reasonably assure the defendant's appearance or the safety of the community. So this presumption may be rebutted. So this means the law acts in an automatic fashion, but the defendant can reverse the automaticness. They can rebut the presumption by presenting evidence that they are not a danger nor a flight risk. Even upon such a showing then, so once defendant makes such a showing, the presumption in favor of detention does not disappear, but rather is just a factor to be weighed. And then that factor, that rebutted presumption, can then be further argued by the plaintiff, the U.S. attorney, the prosecutor. The factors to be considered in the detention analysis here show that defendants present a severe and ongoing danger to the community and a serious risk of flight. Because the law presumes that there is no set of conditions that will reasonably assure that defendant's appearance or the safety of the community are affected, and because the presumption cannot be rebutted for the reasons set forth below, the court should enter a permanent order of detention. So the prosecution is saying that this presumption cannot be rebutted for some reason. They say the defendant's criminal conduct was extraordinarily serious, that defendants committed an act of potentially deadly violence. They sought out and targeted an NYPD vehicle. They created and hurled a Molotov cocktail. They created fire and damage. They constructed this improvised incendiary device in close proximity to others, including placing individuals in grave danger. And with that attack complete, Mattis acted as a getaway driver. The two sought to escape. They had another Molotov cocktail, so they were prepared to burn more vehicles. And this is one of a enumerated set of laws, 18 USC 30, let's take a look, 18 USC 3142 G1. The release or detention of a defendant pending trial. In general, upon appearance before a judicial officer, the judge shall issue an order about their release. Now we're looking specifically for G1. So they were already released on conditions, and we're going to hear a whole argument about G1. G1 says, factors to be considered. G1, the nature and circumstances of the offense charged. The government is saying these are the factors under G, and they're going to get to very quickly here how under E, if you are charged with one of these enumerated factors, subject to rebuttal by the person, so this is again, rebuttable presumption, it shall be presumed that no condition or combination of conditions will reasonably assure the appearance of the person and the safety of the community for an offense listed in section 2332B, which is right here, Section 2332B, which is acts of terrorism transcending national boundaries. So they could rebut the presumption, but the government is going to be saying here that they did not do that. Specifically, Section 844I, which carries a term of 20 years imprisonment, is an offense listed in 2332B of Title 18, boom, and therefore gives rise to a presumption of detention. The defendants then face that, and they have to overcome that presumption. Here they say that the weight is overwhelming. The defendants were caught on camera firebombing an NYPD vehicle. Just minutes after committing the dangerous and violent act, they were arrested with another assembled Molotov cocktail, as well as precursor materials to make additional Molotov cocktails. They have a history. They are licensed attorneys, so they should have known better. They've attended prestigious law schools. As such, the defendants were well aware of the severity of their criminal conduct when they decided to hurl Molotov cocktails at an NYPD vehicle and incite others to do the same. They pose a severe and ongoing risk to the community. They have committed an attack with an incendiary device and sought to aid and abet others in similar attacks. And amid the ongoing social unrest, the government respectfully submits that these defendants, if released, would return to rioting, destroying property, and endangering others. These defendants, attorneys, purported officers of the court, were already acutely aware of the danger they pose to the public in acting in total disregard of the law. There is no reason the court should give them the benefit of the doubt that at this time they will respect the court's orders regarding the terms of pretrial release. So they were released, and for the past week have been outside of the court system, but inside their homes under house arrest with ankle monitors, with GPS and everything. And presumably, if they left, something would happen. Well, that's not good enough for the government, because the government has gone back to court, this time appealing to the Second Circuit Court of Appeals and asking the appeals court to overrule the lower court and revoke the defendant's bail and have the U.S. Marshals pick them up and bring them to jail for detention, to be held in jail, bail revoked, awaiting their trial or awaiting further hearings on whether their bail should be revoked. So the Second Circuit did revoke the bail. The marshals did pick them up Friday night, and that pair is currently sitting in jail in, I think, Brooklyn. This pair of attorneys who committed this act of Molotov cocktail firebombing are currently sitting in jail. And let's hear how they ended up in jail by listening to their oral arguments. So this is what I've put together. This is 20 minutes of oral arguments, but I have whittled it down from about 30 minutes, about 27 minutes down to about 20 minutes. So let's take a listen here and hear what the judge has to say. This is the 3-judge panel of the Second Circuit Court of Appeals.
We'll hear argument first on the motion in United States versus Mattis. Mr. Kessler?
Thank you. Good morning. My name is David Kessler, and I'm an assistant United States attorney in the Eastern District of New York. I'm joined by my colleague, Kevin Trowell. We represent the government in the appeal. The core issue here is danger to the community. This isn't a case about a youthful indiscretion. It's not a case about teenagers with spray paint. The defendants are adults. They are attorneys, and they engaged in violent crime and encouraged others to do so. And Congress determined there's a presumption that no conditions can keep the community safe from individuals who violate the charged statutory provisions.
So this is the government lawyer speaking. I apologize for the audio issues. It was on their end, and I went through and spent an hour editing this, trying to improve it. So just sorry.
Nothing has rebutted that provision. That presumption, or shown that the defendants are less dangerous than they were before they started their conduct. And the district court didn't address that presumption directly. The court took comfort in a series of...
Remind me of the source of the presumption.
It's 18 U.S.C. Section 3142. I believe it's E3C as in cat. So the district court looked at a series of factors like the history and characteristics of the defendant, their employment, the fact that they have family responsibilities and individuals they care for. And those are all conditions that existed before the defendant constructed firebombs or threw one or incited others to do so. So those conditions which existed before the crime can't rebut the presumption here.
This is Judge Park. The district court relied on the bond and the detention conditions and the monitoring conditions to find against dangerousness and flight risks. So
the two lower courts found against dangerousness to the community. Remember, there's two factors, flight risk and dangerous to the community. I don't hear too many arguments about flight risk, although the government says it. The government more concludes it than explains why they're a flight risk. But the government definitely explains that they think the defendants are still a danger to the community, that they're going to go out and riot and protest and cause destruction, even though the court orders them not to do those things. I mean, after all, they're already officers of the court and they disobeyed their extra rules about being attorneys. So what's to say that they're going to obey the court? It's a valid argument, I think.
What's the error? And are you asking us just to reweigh the bail factors, or are you arguing something different?
And the government is mostly saying that the defendants haven't really made the required showing to rebut the presumption. That what they cited was the defendants' good character and the fact that they have families and things. And the government's saying that doesn't count. That it's not that those things don't count for bail hearings, but that they don't count for presumptions like this because those factors existed before and something has to have changed or something. Let's see what they have to say.
No, I mean there's clear error here. There is a firm and definite conviction here, firm and definite position here that the I don't want to say weighing, that the conditions simply do not address the danger that's been evidenced by the conduct. Neither electronic monitoring nor home detention are a physical wall or a tether that would prevent additional conduct. And although there are now sureties and bond, there was great social suasion already. The defendants have relied heavily on the fact that they care for individuals and their families, that they have a sort of special responsibility.
So they did the crime even though they have families that care about them, even though they have support systems. So you would think that having a good support system and having people that you care about, that you want to see every day, and people that want to see you every day, et cetera, that would stop you from becoming a criminal. And it didn't stop them. So how is that something that rebuts a presumption of danger to the community? It didn't stop them in the first place. So how is it an argument that they get to be out on bail? Valid argument, I think.
Caring for particular people in their family, that certainly seems like more of a moral suasion than the sureties on the bond, and that did nothing to stop this, and did nothing to stop the calculation that was required to set these crimes in motion, or carry them out, or incite others to do this. So that's the error, certainly, and that's really the basis that we are seeking a stay as well. The danger exists now. As long as the defendants are in the community. So that's the basis of the application.
Yeah. What is, let me hear you please just address from the government's perspective why these conditions are inadequate. I mean, we're not dealing with ISIS.
So we're talking about bail conditions, home confinement. Why is that inadequate?
I agree. Your Honor, there's no foreign terrorist organization in this case, but what we are dealing with is two defendants who, despite being attorneys and not just knowing this is wrong, but understanding the seriousness of these consequences, took a series of actions designed to cause damage and, designed or not, highly likely to inflict.
Yes, Mr. Lint, this is the kind of conduct that can get an attorney disbarred. Yes, 100%. Yes.
physical injury, if not death.
You have 1 minute left.
Thank you.
Counsel, this is Judge Nardini. Can I just ask a question? I think it's clear from the record, but I'd like it just to be...
All right, so this is Judge Nardini, who asks a lot of questions over the next 15 minutes. And Judge Nardini, you can sort of hear it in his voice. He already has sort of a way he's leaning. See if you can figure it out.
Clarifying. The conditions of home confinement were with electronic monitoring, is that correct?
That's correct, Your Honor. I believe it's GPS monitoring. I can certainly check that. And then there were exceptions for attorney visits, medical visits, and I believe employment, and possibly one or two other exceptions.
Okay, so the bail conditions were that they were allowed to go to see the doctor, allowed to see clients, work, stuff like that. They're just then not allowed to go like hang out at the bar or whatever, socialize.
It's set forth in the record, but those are the main ones.
Is there any condition that physically prevents them from leaving the house, or is it simply the circumstance that the electronic monitoring would at some point alert someone if they choose to leave the house?
That is correct, Your Honor. There is no physical restriction on the defendant's movement whatsoever. There is only the hope that if they chose to leave the house to do something, that would be detected and acted upon before something happened. And I think that is sort of the core of the issue here. When you look at the conduct and the calculated nature of what happened and the extraordinary risk these actions posed, particularly the incitement of others and the attempt to arm others, that is a danger that is great and is not prevented by electronic or moral barriers.
Okay, so the government is concluding that the defendants are a danger to the community and that the presumption of the danger to the community based on the crime charged has not been rebutted. Now we're going to hear from the two defendants' defense attorneys. First, I think Mr. Mattis's attorney, and then I think Ms. Rahman's attorney.
We'll hear next from Ms. Schroff.
Good morning, Your Honor. May it please the court, this is Sabrina Schroff on behalf of Collinford Mattis.
Yes, Mr. Mattis. So the getaway
Your
driver.
Honor, the government is asking this court here today for some extraordinary relief. It is asking for a stay of an order that has already been executed. An order not from one, but from two able and experienced judges, both of whom conducted full factual plenary hearing, adopted the recommendation of the only objective party below, the Pretrial Services Unit of the Eastern District of New York.
So everybody else said bail was okay for these guys.
Which had conducted its own thorough investigation. And it is this group, Pretrial Services, Magistrate Judge Gold, District Judge Brody, who considered all the factors, declined the government's rank invitation to focus solely on the nature and characteristics of the offense, did exactly what they should have, considered every factor under the Bail Reform Act, applied the standard, and the standard is to reasonably assure return to court and reasonably assure safety of the community, and imposed conditions that do just that. So to be clear,
this is Judge Park. The government argues that the district court didn't acknowledge that this was a case where there's a presumption against bail, and I'm wondering if that's correct. Did either the magistrate judge or the district court acknowledge that in its weighing of the bail factors?
Absolutely, Your Honor. Magistrate Gold absolutely acknowledged the presumption. I addressed the presumption and told the court why the presumption had in fact been overcome.
I'm sorry, counsel, this is Judge Nardini. Could you just assist us to direct us to where in the record Judge Gold did that? It would be helpful if you had a page site.
Page 15. And after the whole colloquy, I told Judge Gold, I believe that the bail package completely addresses any concerns at all, and I have fairly rebutted this presumption. The court then goes on to say he appreciates everyone's advocacy, and clearly right before that, on the same page, I address at the bottom of page 14 and on the front of page 15 why exactly
you have 1 minute.
I have overcome the presumption. On page 16, again, Magistrate Gold, and I quote for the court, I have reviewed everything very carefully earlier this morning, and I agree it is a close question. But I also believe that one night of behavior is not a basis to reject someone's ability to make rational decisions, and that home detention assured by the plaintiff and the well-being of his entire family, I'll skip the rest, should be an adequate deterrent for further danger to the community.
So no, the lower court did not expressly address the presumption.
Even assuming...
Ms. Schroff, that's very helpful, that citation. Can you provide us with any citation in which you believe the district court acknowledged the presumption?
I believe it's page 16. If you could just take a look at page 16, right? I address the risk of flight, danger to the community. I point out that both are ameliorated by the fact that there are conditions of confinement under the Bail Reform Act, 3142 subsection F, which address all of these. And look, she doesn't even take it for granted. To Judge Brody's absolute and full credit, she says, she asked me, so the question that the court has is the same that I had for counsel for Ms. Rahman. What is it that assures the court that your client will not decide, despite home detention, to go out and act in the way that he did a few days ago?
I'm sorry, Ms. Schroff, can I just hit the pause button?
So she's saying that the court addressed the issues covered by the presumption, but maybe didn't say the word presumption. You know, the presumption is one that covers whether you're going to be violent again, whether you're going to recidivate or need to be remanded, whether you're going to be a danger to the community, etc. And that they addressed all the stuff that we would address in addressing the presumption, but we didn't actually say the word presumption. So how much does that matter?
On that for a second, because I am looking at the pages you addressed me to, and I'm just, if you could direct me perhaps to the line number, because I'm not seeing it, where anyone addresses, including particularly the court, addresses the presumption.
Well, Your Honor, if you look at lines 12, 13, 14, 15, right?
I'm sorry, this is on page 15 of the transcript?
No, Your Honor, page 16 of the transcript.
16 of the transcript. Okay, and where does it address the presumption?
That is, she's addressing the presumption. She's not using the word, but she's addressing the presumption. She's doing exactly what the government invited her to do. The government...
We just got through defendants' entire oral arguments, and only then did the defense attorney finally admit that they never actually said the word presumption.
It says that the presumption of violence is such that the client will go out and do exactly this again. So she takes the government at its word, she takes their concerns seriously, and she asks me the question. What is it that would assure the court? That's balancing the presumption. She's asking me,
she doesn't say anything about the presumption. Is your suggestion that because the government had raised the presumption, one ought to presume that the court was aware of it, and that's what she was talking about?
Well...
So, in other words, the government brought it up in their memo. In other words, we read the memo, remember? And there was a section in there about the presumption, and you know, it being 2332B terrorist act or whatever. So because the government brought it up, does that mean that the court automatically knew about it and the court was discussing it?
I'm not asking you to presume, because right before that on page 16, lines 1 to 6, I talk about both risk of flight and any danger to the community being ameliorated by the bail condition.
Right, but let's just be clear. There are many cases where a court has to make the dangerous finding where the presumption does not come into play, correct?
Well, of course, but...
Right, so that's, I think my question, just to be clear, is not, did the judge, in your view, address an assessment of dangerousness? My question is, did the judge address the existence of the presumption, which makes this case different from other cases in which the presumption does not apply? So could you just address that specific question?
So the courts normally have to address dangerousness as a bail condition. So you don't normally address this presumption of detention unless it's brought up by somebody. So because the defendants did not bring up the presumption of detention and expressly say, this is my analysis section where I am rebutting the presumption of detention in 3142 and 2332B. Apparently that, because they didn't say those express words, they get their bail revoked. Or maybe they just didn't convince the court either way. Maybe they just really didn't convince the Second Circuit on this. Remember, this is a preliminary stay of the granting of bail. Weird, I know. So normally you would be out on bail and then they would revoke the bail and send you back to jail. So this is granting a stay of the granting of bail, meaning that revokes the bail temporarily until the Second Circuit can fully rule. And so they've already scheduled, I think, a June 10th hearing on it. We'll take a look at that in a second. Let's finish this, though, because we have a whole other attorney to hear from.
Or is it that because it was adequately raised by the government, your view is that one ought to assume that the court was aware of it?
Well, I have to say that the court was fully aware of it because Judge Brody incorporates what happened before Magistrate Judge Gold. And if you look at page 18, right, at page 18, again, she's focused on the dangerousness. What she's doing is what a district court judge is supposed to do, right? What she's doing is she's analyzing the facts about danger, which go to the presumption. So she says, based on the court's reading of the detention memo, and for sure, the detention memo harped on nothing but the presumption. Of course, that's the government's detention memo. So she considered the presumption there. The pretrial services report, which also considers presumption and lists out the factors that weigh for and against bail. And then she says she's considered the argument of the party. Is the government seriously arguing that they were so defunct in their bail application to a district court judge that they did not address presumption? That's ridiculous.
No, so just to be clear, then you're arguing not that Judge Brody articulated anything about the presumption, but simply that because it had been adequately raised by the government, one ought to presume that when the court then addressed the dangerousness factors, it must have also considered the presumption in its calculus.
That's correct, Your Honor, but I'm not saying must have. I'm saying that, you're welcome.
Thank you, Ms. Roth. We'll hear next from Mr.
Okay, so it does appear that this law that allows them to be held without bail is any act of terrorism transcending national boundaries, even if it doesn't transcend national boundaries. Just that's why, because I saw a few questions about that, and they're legitimate questions, like what the heck was going on there. So that's what was going on there. So now we're going to hear from from Rouge Rahman's defense attorney. So I'll back this up just a hair and start it over.
Thank you, Ms. Roth. We'll hear next from Mr. Schechtman.
Good morning. Paul Schechtman for Ms. Rahman. Let me just very quickly begin by reminding the court, and I'm not sure it needs reminding, of the legal standards. On a stay, simply showing some possibility of irreparable injury is insufficient. The standard of review here is clear error. There's no legal issue as far as I can see it. And of course, on the question of dangerousness, it is the government's burden by clear and convincing evidence to show dangerousness. There is a statutory presumption here, but what is clear and important is that it simply puts a burden on the defendant to come forward with some showing. And after that, the burden remains on the government to show clear and convincing evidence. It's not a bursting bubble presumption, if I know what that means. It still has some light. It's a factor, but it is not a presumption in the sense that one often thinks of presumptions. Those are the legal standards. If you put them together, that is indeed a heavy burden. I want to say one thing about the facts. Ms. Rahman was on the street in that night like hundreds of other New Yorkers.
Okay, he's about to say something about the facts. And what do we know about the facts in an appeal? Facts don't usually come into an appeal, right? An appeal is usually an appeal because there's been some error of law or some really big error of fact. And so you're going to hear some questions from the judges about why we're talking about facts and whether those facts are part of the record or whether he's trying to introduce new facts, because you are not allowed to introduce new facts on appeal. You have to have introduced those facts and brought up your legal arguments and appeals and stuff, your bases for your appeal. You have to have brought a lot of those things up below, at least the facts for the basis of the appeal, at least.
To show her outrage over the murder of George Floyd and the systematic racism that is evident. The conduct alleged here shows the following. She had no intent to harm anyone. This was an empty police vehicle, badly vandalized, 1.5 blocks from the police station. There were only 2 other people around. Both of them were taking photographs.
Okay, I'm going to stop here for a second. So does this change your view of the incident? It was an already badly vandalized and abandoned police vehicle. I don't mean abandoned as in anyone could claim it and she had the right to burn it down. No, I'm not talking about that. I just mean that it wasn't occupied by police officers. It wasn't in the middle of a dense urban area. I mean, yes, it's an urban area. Yes, the population density is dense, but there weren't people around. There were only supposedly 2 other people around, including the photographers that took the pictures we looked at before. And then, of course, one of them turned out to be the witness, I guess, against them. And so there's only like 4 people total around, and they come across this scene 1.5 blocks from the police station where there's a broken into abandoned police car, and so they decide to burn it out. Is that the same thing as we revoke bail for terroristic acts? Is that the same thing? I don't know. You can sort of weigh that in your mind as we keep listening.
There was no crowd nearby.
I'm sorry, Mr. Sheckman, this is Judge Nardini. Could you direct me where that fact is in the record? That there were only 2 other people nearby?
I think the government will confirm it, Judge.
Well, yeah, could you direct me to where it says in the record?
Do you detect just a hint of, adversity in Judge Nardini's voice? I have a feeling the judge does not like that the attorney is trying to bring up facts that aren't in the record.
I'm not sure it was said below. It's awkward for a lawyer, Judge, because I have a presumption of innocence here, as did the lawyers who had this below.
So can I just pause you? Are you saying that's you're citing to me a fact that's not in the record? Because I'm assuming then we'd have to talk to the government and see if they'd like to proffer any additional facts on their part, right?
I'm not offended by that. I think they will confirm that there were 2 photographers around, and I think they will confirm that the only person who was offered a device was one of those photographers and offered it to throw into the same abandoned van. Those are the facts here. This was lawless. This was stupid. This was 2 people swept up in the moment. But it is 2 people with no history of violence, no criminal history at all. There's no real planning here. What it requires to do this is stopping at a convenience store. There's no membership in any organization.
I'm sorry, Mr. Sheckman, it's Judge Nardini again. Did you just say that all the materials could be gotten at a convenience store? Does that include gasoline?
If you stop at a convenience store that has a gas station, gas pumps in front of it, the answer is yes, Your Honor. This is not.
Well handled. The judge is like, yeah, you can't get Molotov cocktail ingredients at a convenience store. You need a gas station for that. Okay, so how about I go to a convenience store gas station? I love that little exchange.
Anything in the way of planning.
Excuse me, you have 1 minute left.
So, and then the last thing I would say is that, and this is not in the record, but I think it's important. There were 1,300 people released last year in the Eastern District of New York, a third of whom were on electronic monitoring. The court can confirm what I confirmed this morning. 3% of them were remanded. This defendant was rated in the lowest category for electronic monitoring.
So that means they were rated in the lowest risk category for electronic monitoring, that there were 1,300 people on electronic monitoring, only 3% needed to be remanded, and these guys are in the lowest category for flight risk and danger to the community. So the commenter who asked whether their 5 days of history already that we've been electronically monitored for 5 days. There's been no problems. Will that come into it? No, but they tried.
Perhaps most importantly, since her release, that is Monday night, Tuesday night, Wednesday night, Thursday night, there have been no issues whatsoever. Her record has been perfect. There was one other person arrested that night. They have 11 arrests in 11 states. Right? This defendant, Ms. Rahman's travel, consists of an hour each day from Bay Ridge to the Bronx to help poor people who are facing eviction. This is a defendant who made a mistake in judgment, but to remand her to the MCC is also a mistake in judgment. The judges below, both of them were experienced. I mean, Judge Gold has been doing this for 20 years. He knows there's a presumption, and he knows conditions of release that are reasonable. Judge Brody was a prosecutor for 12 years before she was a judge for 8. These are experienced, respected people of sound judgment, and respectfully, they got this one right.
So defendant Rahman's attorney, I forget his name, he's arguing that she's not a flight risk, that she's been a good person, that she does, have a job and she works and she commutes to her job and everything, that her job is helping people, she does a good job. She helps people who are being evicted. And all that's great. But the government argues that none of that stuff stopped her from doing it in the first place. So what's going to stop her from doing it again? In other words, she got caught once. Is that the sole reason that she's not a flight risk and not a danger to the community, is that she got caught, therefore she'll stop? I don't know how great of an argument that is. And it turns out to not be a winning argument in this temporary stay issue.
Thank you, Mr. Sheckman. Mr. Kessler, you reserved 2 minutes.
Thank you, Your Honor. Let me be brief.
So this is back to the government's attorney, the prosecutor.
On the idea that the defendants were swept up at the moment. I mean, that's simply not what the record shows. The record shows they had to gather materials. They had to construct multiple firebombs. They had to find a target. They had to use them, and then encourage at least one other person to use it. So they were not swept up in the moment, whatever else those facts show. I also just want to...
So this wasn't a situation where somebody said, your mom's a jerk, and you just hauled off and punched him in the face. No, this is not a crime of passion. This is not a crime that happened in the moment. They had to they had to leave their residence, get in their car, go to the store, a gas station convenience store. They had to bring empty bottles of Bud Light or buy Bud Light or something to fill up with gas. They had to get a gas can. They had to get tissues or whatever they used to start the thing, to hold the flame. They had to get a lighter. They had to buy the gas. So you're doing all these things. These things take minutes. So how many minutes before this becomes, hey, we should reflect on this. Are we doing the right? Are we the baddies here? Yeah, they should have been able to take a moment and reflect in that time. And the fact that they didn't have the good judgment to do that, the government is arguing, should be counted against them in their bail revocation hearing, basically.
Briefly touch on, I think it was Judge Nardini's question about the presumption. The presumption is a factor here. It's not the only thing we're relying on, but I do think it is worth noting that, in fact, Judge Brody did not explicitly discuss the presumption as the statute requires her to do. The bigger point here is the risk of dangerousness, which is supported by the facts, not just the presumption.
And this is Judge Nardini. Could you just respond
again
to counsel's comment that there were only 2 other people around? Is that fact contained in the district court record anywhere?
Your Honor, I don't believe the number of people around was contained in the district court record.
Excuse me, you have 1 more minute.
If there are no further questions, government will rest.
Thank you, counsel. We'll take it under advisement.
Okay, and that's what Zoom oral arguments sound like. And then so that was Friday morning, the 5th of June. And later that day, the Second Circuit did grant the stay the stay revoked the bail, and the marshals came and got Erouge Rahman and Collinford Mattis and took them to, I guess, MCC, is that Metropolitan Correction Facility or Correction Center or Correction System or something like that? I don't know what MCC is. Somebody let me know in the comments. I'm sure you will. So that's how 2 attorneys ended up being arrested for firebombing a New York City Police Department car, 1.5 blocks from the police department in Brooklyn on DeKalb Avenue. Yeah. So yes, they both have jobs. Not anymore, though. So Mr. Mattis worked for Pryor Cashman as some kind of clerk. He was in, I think, his early years as an attorney, and so he has been suspended, and I'm assuming will be fired once he's convicted or pleads guilty or more information comes out. I don't know about Ms. Rahman's job, but I'm assuming they're also going to not be wanting her to work for them. 1, she's now in jail, so she can't work for them. And 2, who knows if she'll be maintaining a law license after this. They the government, the bar licensing bodies, state bars like New York State Bar, probably look disfavorably upon firebombing the law enforcement, vehicles, conveyances. I think they look down upon that. So that's what's current. That's the current status of the Molotov cocktail attorneys. We'll follow up with that and bring you additional stories as they happen. What do you think? Let me know in the comments below. I'm mostly speechless that these people, they've got such great things going for them. There's no need to firebomb a New York City Police Department car. Trust me, peaceful protests can create just as, in fact, I think a peaceful protest creates a more effective message. I think a violent protest undermines the message of a peaceful protest, and violence shouldn't be used in protest. Violence should only be used when violence is necessary, and I don't think that is necessary when we have peaceful protest options available. So let me know what you think in the comments below. What you think of the underlying act of firebombing a police car, but then was it just like a one-time act, and now they've been caught, now they should be out on bail while we've got them on electronic monitoring? They pay for the electronic monitoring too and stuff. It's not like they're out like gallivanting around, but they are probably still able to go to work-related activities. Like Mr. Mattis can probably go look for a job, and Ms. Rahman can probably still go to her job as long as she has it. So they have lives outside of jail, but not anymore. So was it right to revoke their bail? I saw someone saying that it was civil rights. Is it a civil rights violation to have no bail, but they're charged with firebombing a police car? So, and it's a rebuttable presumption, so it's not like you automatically get no bail. They just didn't make an adequate showing that convinced the Second Circuit. And then it's still not over. The Second Circuit is the appeals court. We only got to the appeals court because the government disagreed with the lower court. We're only at the Second Circuit still because they're actually still hearing the case, and this was a temporary stay. So the defendants are gonna be in jail while we have a temporary stay, and then once we decide what to do, then that will be what is sent to the lower court to enforce, and that will be probably bail conditions or revocation of bail, one or the other. Let us know what you think. So that's our show, everyone. Thank you for joining me. Let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel. This is a community-supported channel, meaning we need your financial support. Thank you to the following monthly supporters on patreon.com/ljfrench and sponsors.com/law, and YouTube memberships and Floatplane members. At the $50 plus support level, thank you to Joe Tyson, West Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian, Hellman, Jay Dixon, Ameknight, and Oscar the Phrophet. And thank you to the $5 plus supporters who are scrolling on that LED panel behind me, and everyone will be in the description of the videos that drop. I love you all. I will see you later in the videos that drop. Bye.
Oh, no. I like to look back like yeah, like that.
Like that.
We're not a scuba dog.
He does, he puts his nose under the water. Yeah, does that feel good? Get yourself all hot and then run into the cold water. And run around, you're gonna rub your head on the grass. Are you just a happy dog? Are you just the happiest golden retriever? Well, I'm sure there could be happier golden retrievers. There could be a pack of golden retrievers. I bet you that would make you very happy. Yeah, right?